Hello, I'm Shane Stark, President of the League of Women Voters of Santa Barbara Education Fund, and I welcome all of you to the November 2020 Pros and Cons Forum hosted by the League of Women Voters of Santa Barbara and its Education Fund. During these interesting, or to use my mother's favorite word, dreadful times during this COVID-19 pandemic, we hope that everyone is safe and well. Please note that this meeting is being recorded. The recording will be posted on YouTube on the League's website, www.lwvsantabarbara.org, a day or two after the forum. Because this is the first time we're holding this forum via a Zoom webinar, here is some information about the logistics of the meeting. A webinar is different from a regular Zoom meeting because the attendees are muted and you cannot see the other attendees. The only people who will be visible to you are the panelists, myself and Chris Bosch, a longtime member of the Santa Barbara League. Both of us have previously hosted pros and cons and other league forums. Assisting behind the scenes are League members Reve and Anthony Moran. The purpose of this webinar is to inform the voters about the propositions, the state propositions that is, and the local ballot measures that will appear on their ballots in the presidential election in November 2020. The Education Fund does not support or oppose any propositions or ballot measures. The League of Women Voters is nonpartisan. It takes positions on issues but does not support or oppose candidates or political parties. I want to take a brief moment to explain the initiative. The initiative, the referendum, and the recall are three things referred to as the great rights of the people. They were originally designed in the early 1900s as a check on the state government that had become unresponsive or antagonistic to the will of the people. So as you can see by the racing bear and the little people's mesa rat with the dynamite at the bottom, it is a very powerful reserved power and sometimes is very difficult to check. I would remind people in the audience, when you look at an initiative, it's not like looking at a candidate, it's a law. So you have to pay attention to details and read carefully. I will note at the end of this program, we're going to have a list of resources put on by the State League of Women Voters for you to look up and go in detail as you wish for information on these ballot measures, in addition to the very useful information that will be in your official ballot pamphlet from the state. For today's format, we have grouped the 12 propositions on the state propositions that'll be on your ballot into 4 groups with similar topics. Each group has 3 propositions. As we discuss each proposition, if you have questions, please type them into the Q&A box at the bottom of your screen. That's the chat box. My wife has reminded me from the distance that this is called the chat box, I believe. At the end of each group of propositions, we will pause to answer the questions asked. Time permitting, a member of the league is standing by to screen your questions for relevance and to avoid duplications. When we finish with the state propositions, we'll cover the 2 school bond measures, Cold Springs and Goleta School District, and 1 local measure for the city of Goleta. I would mention we will be brief in this endeavor. Chris, the first group is proposition group 1, we call it. Very imaginative. Chris, are you ready here?
Am I heard?
Oh, I hope so. You're heard. And seen.
Okay. Hello, I'm Chris Bosch, and I get to start off this adventure into our measures that will be appearing on the ballot for this election. It can get pretty mind-boggling, so I want to assure you that there are considerable amounts of information that are in your official voter's guide that you should have all received, and that at the end of our presentation today, we will let you know where to find some very, very helpful tools that the League of Women Voters California has put together. So if you're finding yourselves lost in the dialogue, please know that there are resources that you can check. The first proposition that we take up in Group 1 is Proposition 14. It has a history in that in 2004, voters granted them money as well as added to the state's constitution to allow for stem cell research. You might remember the controversies around that. And it also created the Institute for Regenerative Medicine. This institute is running out of money after working diligently for the last 16 years. So they are now requesting to have $5.5 billion in new bonds to continue funding grants for research and development of stem cell treatments. That's the major question you have to answer as a voter. The bonds are sold over a span of at least 11 years. So 5.5 billion doesn't suddenly become the debt to California. It's spread out over 11 years, and it's limited to $540 million a year to finance the Institute. Prop 71 in 2004 was passed by 59% of California voters. So they are looking forward to that support again. Cost to taxpayers will be about $260 million a year over a span of about 30 years. That constitutes, the debt itself constitutes less than 1% of current state general funds. In this proposal, administrative costs are limited and cannot exceed 7.5% of the funds that they receive. And California continues to be entitled to revenue from new inventions or treatments that result from the Institute's grants. Now's the time, if you wish to ask any questions, you may. Or Shane, did you want to add anything more?
No, I thought we were going to have the questions after the group of 3.
Oh, I'm sorry.
That's okay. No problem.
I should add, I'm sorry, that the supporters for this bond, or this Proposition 14, oops, excuse me. The supporters are saying that California stem cell funding has led to significant advances in treatment and cures for many diseases, including over 2,900 medical discoveries. It is supported by over 70 patient advocate organizations and will increase patient access and affordable treatments and provide patients, their families, and caregivers with financial assistance. Prop 14 will contribute to the rebound of California's economy. Funding to date has generated about $10.7 billion in economic stimulus. Opponents point out that California cannot afford a $7.3 billion expense in bonds, particularly in the middle of economic crisis, and repayment of the bonds will increase taxes. Previous funding has not yielded the promised results for treatment or economic benefits, according to them, and private investors and companies have made great strides in stem cell research and cures. Opponents also say that independent analysts and news outlets have questioned the management, integrity, and transparency of the Institute. Now we're ready to move on to Proposition 16. The question here is, should California and local government entities be allowed to consider diversity as a factor in public employment and education and contracting decisions? Before 1996, California had an affirmative action program. In 1996, however, a voter-approved proposition generally banned any kind of diversity considerations. The proposal before us is, should we repeal the section of the California Constitution that was introduced by Proposition 209? And as a result of reintroducing this, states and local entities could establish a wider range of policies and programs that are also consistent with federal and state laws relating to equal protection. We cannot, or they cannot assess the fiscal effect of this until it is known exactly what kinds of programs and policies are established by state and local entities. Supporters say that Prop 16 means equal opportunity for all Californians. Despite living in the most diverse state in the nation, women and people of color currently are still discriminated against. We are at a historic moment and need to strengthen California by overturning discrimination in all areas. Opponents say that approval of Prop 16 would be a step backward, introducing a new form of discrimination to favor politicians' favorites. Let's not perpetuate the stereotype that minorities and women can't make it unless they get special preferences. Prop 16 will require costly bureaucracies to enforce its provisions and burden taxpayers. Keep in mind the questions you might have about this. Proposition 24 changes to consumer privacy laws. Such existing law from 2018, the California Consumer Privacy Act, would be amended to increase penalties on companies that fail to follow regulations, to allow consumers more to opt in and out of sharing their data, changes criteria for which the businesses need to comply, and to create a new enforcement arm that would cost about $10 million annually. The support for the proposition from 2018 is supported by the same person now for toughening its provisions. The categories of businesses affected are affected by dropping what was called a device count and limiting it to just homes and individuals, or households and individuals, and raises the threshold from $50,000 to $100,000 from whom data is bought, sold, and shared, with a profit margin of at least 50%. The consumer-directed privacy rights include making corrections. Increased penalties with less time to correct violations or breaches. It's also part of this proposition, as well as the addition of an agency called the California Privacy Protection Agency that would cost $10 million a year. Part of its problem has been the complexity of the 52-page document that describes the proposition, because the impacts and nuances are difficult to discern.
Thank you.
Did you have anything to add to this?
A couple little tweaks. I would note that with respect to Proposition 16, there is a federal law which implies a certain, the default is how the federal courts interpret the Equal Protection Clause regarding affirmative action, which if I understand right, you have to demonstrate a compelling state interest and show that the remedies that you're doing are narrowly tailored to meet that. With respect to both Proposition 24 and Proposition 14, I know we've got a bunch of questions on it. I would note that both of these come complete with a big, long, horrible looking statute, which has many, many detailed provisions if you want to dig into them. I don't know that we can answer the minutiae of the propositions, but both of them have them. Anthony, do we have questions?
Shane, we do have a number of questions, mostly on the first proposition that was discussed. Before I get to those, I would like to ask all of the participants to please enter your questions into the Q&A box, not the chat function. For a webinar, it's just much easier for us to absorb the questions if they come through as Q&As. So the first question, I guess for Chris would be, is there a provision for where the stem cells come from?
Yes, well, no. Part of the controversy in 2004 was that embryonic stem cells were being used for stem cell research. The availability of stem cells as the result of the past 16 years of research has expanded the availability of types of stem cells. So they're no longer dependent upon embryonic stem cells. I hope that answers the question.
Is the use of embryonic stem cells prohibited, do you know?
It's not prohibited, and it's allowed by the California Constitution.
Okay, thank you.
Another question, will discoveries of the Institute be available to the public for free?
I can't answer that question. The results are shared. The grants themselves have to go to California institutions, but they have built over the last 16 years many state cooperative arrangements as well as international. They reserve rights on discoveries and treatments, not 100%, but a portion of the proceeds from those come back to the Institute. And there's a provision in this law to strengthen the amount of aid that would go to people who are having financial difficulties in procuring these treatments, because they can be expensive. So there is certainly some awareness and thought going into this.
And Chris, one more question on this same proposition.
Mm-hmm.
Have there been any specific stem cell treatments that the Institute has generated?
They have several clinics. I would first of all urge you to go to the site. It's California Institute of Regenerative Medicine, and you can see what they report. At the current time, the only FDA approved stem cell based treatment is for leukemia, known as bone cancer. And some significant research had been done in the Institute in that respect. They have several clinical trials, and certainly we're learning with the development of a virus to treat the coronavirus that clinical trials can be difficult and long-term, and they need to consult with an awful lot of factors that can affect how effective a particular treatment is. So they do have several clinical trials in process, so that the basic research has been done, and now they're looking to see what are effective treatments.
Thank you, Chris. I think in the interest of time, we need to move to the next section. I would like
Sure.
to mention for one of the questions that was asked that yes, this webinar is being recorded and it will be posted on the League website so it can be watched again. Shane?
Yes, I would also like to answer a question, which is, are we in this program going to take any positions on any of the initiatives? The answer is no, we don't. This is the education arm of the League of Women Voters, and we don't take positions for or against ballot measures. There will be a League of Women Voters, this separate program in which they'll discuss the measures on which they took positions and explain them, but that's not what we're doing here. Shall we move forward? Okay. The next group of propositions concerns property tax and residential rent, and that is notably Proposition 15 and Proposition 19, both of which amend the section of the California Constitution that is commonly referred to as Proposition 13. Number for it is Article 13A, and it has the limitations on what the government can charge with respect to property tax. They do different things and do not conflict with each other. Proposition 21, which we'll discuss briefly after that, expands local government's existing authority to enact rent control on residential property. Let's talk about Proposition 15 for a bit. Many people, in fact, I might say most people, certainly most homeowners, are familiar with Proposition 13, which limits the amount of property tax, real property tax, that can be charged to somebody based on the date it was acquired, commonly referred to as the base year, which can only increase by 2% every year. That's known as your Prop 13 assessment protection. Currently, all forms of real property are taxed the same way. There's a common rate throughout the state. 1% full cash value that's the rate. Commercial property, agricultural property, residential property, all taxed the same way. There are exceptions for properties that are restricted, notably agricultural properties that get special tax credit under the Williamson Act and the Farmland Security Act. But for the most part, your property is prevented against tax increases above the 2% every year. Proposition 15 would change that in favor of phased assessment at full cash value. That's the fair market value of large commercial and industrial real property. That's what it does. It's sometimes referred to as a split roll because your county assessor keeps a roll of properties, and in this case, he would keep one roll for those properties that are assessed either annually or somewhat regularly based on their current market value, and those properties that retain their Prop 13 benefits. Under Prop 15, residential, agricultural, and I would note that the specific language is real property that is used for commercial agricultural production, and small business properties. That's properties with less than $3 million of market value. Those properties all will remain assessed under Prop 13. Nothing will change with respect to those properties. The commercial properties are going to be assessed at market value, and the increased revenue is going to go to the schools at the same percentage of revenue that they get now, which is about 40%, of which I think it's 89 to 11 between kindergarten through 12, and community colleges are going to get the increased increment of revenue to the schools, and it's going to be divided up according to the present formula. I believe that there is a minimum amount of revenue that a school can get as a result of this. Local governments will get the rest of this, and this will be divided up among the counties, allocated by the county auditors among the tax entities as the cities, the special districts, and the counties. Within each county, they'll get 60%. Well, or at least those people served by Cox Communications. I think where I was with talking about Proposition 15 with respect to the split roll, was I not? Yes. Okay. Let's review for a second. We talked about what it does. Proposition 15, the last thing that it does is it cuts the property tax. So review the fiscal effects of this. Proposition 15 is expected to generate an additional increment of somewhere up to about $12 billion per year, and you have to take out some costs from that for the local governments, the schools, and some for the state. There will be some costs for counties, particularly for county assessors, and I believe the state's going to lend the county, or they say they're going to lend the counties money, and it'll get repaid when the tax increase increment starts rolling in. Anyway, let me get to the arguments pro and con on this. The primary supporting argument for this is it raises millions of dollars per year in needed revenue for schools and local governments. The funding shortfall, which was already in existence when they started petitioning to put this on the ballot, has been exacerbated by the Depression and the COVID-19 pandemic. So there's a big need for the extra money. The proponents say that the lag of the turnover with corporately held properties whose change of ownership was avoided by various mechanisms exacerbates the existing inequities in Proposition 13, and they say this is a loophole which is plugged by Prop 15, and they note that it only applies to large commercial enterprises, and it's stressed that it exempts residential property, it exempts property used to produce agriculture, it exempts small businesses. All these types of entities continue to retain the Prop 13 benefits. The opposing argument, pretty simple. This raises taxes in the middle of a depression and a pandemic is the wrong time for a tax raise. Businesses are going to pass their costs on to consumers, and the increases are going to hurt small businesses and agriculture. This is the biggest increase in California history. Big administrative costs. Those are the opposing arguments. I see my colleagues, power is returning to my colleagues now. This is all good. Let me talk about Proposition 19, the other measure that amends Prop 13. In the status quo, the way things are, certain types of homeowners, if you're over 55, if you're disabled, or if your property was damaged or destroyed in certain types of natural disasters, you can get a replacement home and keep your Prop 13 assessment. This only applies once in a lifetime. It only applies in the same county with narrow exceptions that don't apply in Santa Barbara County. And hi there. And it only applies to property that's the same or lower value. Any event, Proposition 19 would amend this. It would amend the property in two critical respects. The first critical respect is it would expand the portability of your Prop 13 values if you're in one of the classes of people that can transfer them. It would enable you to transfer it anywhere in the state. 3 times in your lifetime, you could transfer it to a more expensive home, a less expensive home, and there's a whole mechanism in there to calculate which counties lose and which counties gain, and to reimburse the counties that are negatively affected by this. The second thing that it does, which is pretty critically important, is it modifies the current exemption. Well, I'll back up. Under current law, which has been considered by the voters several times, a parent may pass their property on to their heirs, to their children, and the children keep the Prop 13 assessment. The same applies when grandparents pass their property to their grandchildren and the parents are not alive. This inherited property over time has been abused to some extent by people that own inherited property but don't live in it, they rent it out. Proposition 19 changes that. It changes that in two significant respects. One, it says that the retention of the Prop 13 assessed value only applies if the heir uses the property as principal residence. No, you can't get the assessed value and then have commercial exploitation of your property. The second thing is it provides that if the market value of the inherited property is $1 million or more greater than the assessed value, then it can be reassessed at market value. That's basically what it does. There's some mechanism that they have to repay state and local firefighting costs, but I will tell you that's mostly kind of a remnant left over from an earlier version of this, which is an initiative. This particular version placed on the ballot by the legislature as a constitutional amendment. Here are the Prop 19 arguments. First, I'll talk to the fiscal effect very briefly. It'll probably increase local government revenues by in a total in the tens of millions of dollars over time. Some local jurisdictions will suffer as a result of the transfer of Prop 13 values into their homes. And if home sales increase, then there would be additional residual tax effects. Could be a pretty big cost savings to the state for fire profession costs. The supporters of Proposition 19 say that this expands the protection for homeowners by allowing transfers anywhere in the state, and then it closes what they refer to as a tax loophole for the inherited property. The opponents counter that by saying 3 times the voters have chosen to retain the retained assessment for inherited property, and that if you reassess inherited homes to market value, you're going to force people to sell their property because they won't be able to pay their taxes. That is Proposition 19. The third of the propositions that we're going to discuss in this group is Proposition 21. Proposition 21 incrementally expands the existing system of California rent control. I'll tell you at present, California cities and counties, under their police power, may regulate rents in residential properties as long as they do, in order to alleviate what's a well-known and obvious housing shortage, and particularly shortage of affordable housing. There are two critical constitutional protections that are given to the owners of property. The first is due process of law, which means that before you interfere with the owner's property stream, you have to give them notice and an opportunity to be heard, some sort of meaningful opportunity to contest price increases. The second thing you have to be able to do is you must give the owner a fair return on the property, some form of profit. They don't have to have unlimited profit, but you have to give some meaningful, fair return on property in order to avoid another constitutional violation, which is referred to as a taking of property. That's Proposition 21. What this under current law, most residential rents may increase 5% a year beyond what's allowed by local ordinance, and may not increase. They may not be regulated upon vacancy. There's no such thing as vacancy control under current law. There is another law which requires just cause for eviction. So there's some degree of eviction protection, but there's no vacancy control, and there's rent control. It's limited to 5% a year. Under Proposition 21, I will point out that under current rent control, you can't put rent control on anything that was built after 1995. Under Proposition 21, local jurisdiction's authority to apply rent control extends to any property that's older than 15 years. And they do impose a form of control upon vacancy. Rent increases on vacancy are limited to 15% over a 3-year period. Those are expansions of the existing rent control authority. Nobody knows the fiscal effects of rent control. There are all sorts of speculations. Generally speaking, it puts a damper on the market, but the effects, many of the effects are underground and unknown and unknowable. As a general matter, tenants love rent control and property owners hate it. So not surprisingly, the arguments in favor of this are from tenant advocates who claim that this will expand and the ability to protect people from unaffordable rent increases in difficult times. And the opponents say this will have all the negative effects of rent control. It will deter construction. It will lead to a decrease in maintenance and other common sorts of arguments. And another additional argument by the foes is that it will retard the ability of California to recover from the recession and the COVID. Now, Anthony, do we have any questions as to any of these fine propositions?
Shane, I have a question, which is, what did I miss? My internet has been out for the past 15 minutes, and so I'm afraid I haven't been able to follow the questions. I'm hoping that Vijaya may have been able to.
I've got 6 in my chat room.
Yeah, so
They just say we can hear you.
yeah, Shane, one question. This is about I believe it's Prop 15. As we know, 3 million in property isn't what it used to be in some areas. How will the increase impact flight of medium-sized businesses? How will the increase impact the flight of medium-sized businesses from California?
That's an interesting question. One would have to speculate on it. one could say that as more and more businesses achieve a nominal $3 million in value, which I think is the point, that if they're subject to annual assessment at full market value, that it might cause people to want to establish their businesses in other states or move to their business to other states. I don't know how you could quantify that, but I think that would be an argument that could be made. I'm sure there are rebuttals to it. I see one other.
Yeah, so there's one on Prop 21. Does this apply to every city or only cities that choose to control rent?
I see it's from our former voter services director and my old neighbor, Susan Horn. Hi, Susan. The answer to the question is it is not mandatory. The state law that is currently in effect that limits existing rents to 5% plus, that's mandatory, that's statewide. The Proposition 21 only authorizes cities and counties to adopt rent control. It does not mandate it in any way.
Okay, I think we can go on. There's one on the regenerative medicines grant going back to the Institute of Regenerative Medicine on the stem cell proposition.
I'd reiterate Chris's
Yes.
suggestion that you look at that website because they have a lot of detailed information on that.
Chris,
Yes.
would you? So it says, what has been the financial return to California from the IRM, the Institute for Regenerative Medicine's grant?
Oh, if you could
to
take,
research?
I retired that piece of paper. Let me just check real quick and see if I can find it.
There's an answer.
There
To date-
is.
To date, the inventions from grant recipients have provided approximately $350,000 to the state of California.
Yes, thank you. I'm glad you had that because I did too.
And then we have a generic one which says the LWV did not take a stand on 15 and did on 16 and 24. Will you be taking a stand on 15? Why not?
I can answer that one. The reason is because we're the education fund. We don't take a stand on any of these propositions. We try to objectively analyze them. The league, both the state league and our local league, has taken a stand on certain of those propositions, and you have to ask those folks why.
Thank you. That's it. No more questions.
We're good. We're up to group 3. Chris, you're on.
Oh, a little bit of a miracle. My power went out as well. And so I was fumbling around trying to find a way to get reconnected because our server went down completely. So here we are at group 3, industry specific issues. We have Prop 22, which exempts act-based transportation and delivery companies from providing employee benefits to certain drivers. Welcome to the gig economy. The question is, should app-based rideshare and delivery drivers be classified as independent contractors, not employees, and require rideshare and delivery companies to adopt labor and wage policies unique to these drivers? This situation might affect even more now than the numbers that we have, which is between 800 and 950,000 Californians who provide rides and deliveries each year. They are currently classified as employees by a bill, the Assembly Bill 5, which move them from contracted employees, independent contractors, to classified employees. That is a legal issue right now, I believe.
There are, yes, if I might jump in here, There are
Yes.
a number of lawsuits,
Okay.
notably a lawsuit in which the state attorney general is suing Uber and Lyft. I don't know if they're suing any other companies. They're suing Uber and Lyft to force them, get a judicial order to make them treat their drivers as employees under this statute that was passed to implement a court decision. So that's being contested in the courts pretty much all over the state.
So
Go ahead.
so it is a legal battle, as well as now a battle for citizens to weigh in on as to whether or not the employers are heard and have their the people doing the driving for them as independent contractors, or with the people who are the drivers and currently classified by law as employees.
Yeah, I don't want to mislead anybody here. It is pretty clear that under the test that the state Supreme Court adopted and is in the state statute that the legislature adopted, that those drivers can't pass the test for an independent contractor. They can fight it in court, but it doesn't look like they're going to get very far with their arguments. They're federal laws, but that they don't quite enter into it. So that they may be fighting, but this initiative is clearly intended to amend that statute, to carve an exemption from that statute, and to like terminate the court fights.
So the supporters of this particular measure or proposition is that classifying drivers as employees, as required under AB 5, would lead to longer wait times, higher prices, and less access to rideshare and delivery services. Like AB 5, Proposition 22 would improve delivery and rideshare work by requiring companies to provide new benefits and expand public safety protections. Those people who are opponents say that Prop 22 would eliminate basic workplace protections and replace them with lower guaranteed earnings and healthcare subsidies to save costs for the company. Current law does not limit driver flexibility. A majority of drivers work 30 or more hours per week. And then we get to a return argument, a return plea to the voter to clarify what is going to happen with state requirements for kidney dialysis clinics, and if a physician needs to be required on state or in each clinic. The final stage kidney disease treatment is usually 3 times a week, lasting up to 4 hours. This proposition proposes that a physician can be required to staff state-licensed outpatient clinics, offer the same level of care regardless of a patient's level of insurance, be it private, Medicare, or Medi-Cal, report infection-related information, and require state health department approval for reduction of services in the clinics or actual clinic closures. Supporters say that patients should have access to a physician on site whenever dialysis treatment is being provided. Proper reporting and transparency of infection rates encourages clinics to improve quality. And finally, that strong protections should be provided to vulnerable patients when clinics close. Opponents say that Proposition 23 would force community dialysis clinics to cut services or close, putting lives at risk. Prop 23 would make our physicians' shortage worse and lead to more overcrowding in emergency rooms. Dialysis clinics, opponents say, are already strictly regulated and provide high quality care. Is that something that you would like to weigh in on?
No, you're doing great. You're doing great.
Okay. So on we go to Proposition 25. It replaces the money bail with a system based on public safety and flight risks. And here I do depend a bit on the lawyer and residents here. The question is, should the law enacted by California legislature to replace the current money bail system be approved? In 2018, the legislature passed SB 10, which would do away with the money bail system so that people arrested or arraigned in court might not have to post bail in order to stay free pending their trial. Pending their trial. SB 10 did not go into effect because this referendum was filed, so it's up to the voters to decide. The proposal would eliminate the cash bail system. The legislature would replace the cash bail system with risk assessments to determine whether a detained suspect should be released before their trial. To do this, the state would create a system of risk assessments, which would categorize suspects at low risk, medium risk, or high risk. Suspects deemed to be having a low risk of failing to appear in court and a low risk to public safety would be released from jail, while those deemed a high risk would remain in jail with a chance to argue for their release before a judge. Those deemed a medium risk would be released or kept in jail. In some cases, many people suspected of misdemeanors would be automatically released. The supporters of this proposition say that the current system favors rich defendants who can easily make bail and keeps poor defendants and defendants of color in jail. They also say that people who are eventually found not guilty or not even charged may be stuck with large debts to pay off of the bail or the fees. Opponents to this proposition say that the intentions of SB 10 are good, but its provisions may effectively result in more people being jailed than under current circumstances. Prop 25 would cost taxpayers hundreds of millions of dollars a year, overburdening courts and creating a new bureaucracy. Shane, will you weigh in on this?
On Proposition 25, the only thing I would weigh in on this is I would commend to anybody who's really interested in the gory details of this. I believe it's in Administrative Office of Courts has put out a pretty detailed guide to SB 10, which has got all the detail you ever want to know. The one thing I would point out, people should be careful about this. This is a referendum, so the voters stand in the shoes of the legislature. So if you like the bail reform law, you vote yes on Prop 25. If you don't like the bail reform law and want to keep Dog the Bounty Hunter and the rest of the bail industry and business, then you vote no on Prop 25. That's yes means you like the law, no means you don't. We have questions. You're not going to get off this easy because we have several questions.
We do have questions, Shane. The first question is, does the estimated cost of Proposition 25 include the savings of not having as many prisoners?
The estimate, I don't.
Yeah, the estimated effect from the attorney or the legislative analysis would indicate that they can't do it, that there's too much uncertainty, and it would depend on how the law would or the proposition would be interpreted and implemented. The new release process would increase the workload of state trial courts, district attorneys, and public defenders. These costs could be in the mid hundreds of millions of dollars annually. On the other hand, there could be reduced jail costs if fewer people are being held in jail or for shorter periods of time. And that's where the uncertainty is.
I think what cannot be predicted is how many people will be remanded to jail as opposed to being released on their own recognizance. And there's no way of knowing that until you get some history going, so you can figure that out. But the law isn't predictable one way or the other.
Okay, how about a question about Proposition 22? Are there any limits regarding the number of hours a person spends per week working? And does employee status apply to one who only works a few hours a week?
It's my understanding that those people who are essentially working full-time would remain being referred to as employees. The subcategory of individuals that work fewer hours or do not want to abide by the structure that's imposed by the company would be contract employees. So if those who want to remain independent and are making decisions in terms of whether or not they would carry out a pickup or not, those that want to have a break time that maybe it would not be convenient to the company, they would be wanting to make those independent decisions, and they would remain independent contractors under this proposition.
And another question about that proposition, can you discuss how it would affect minimum wage, sick days, and health insurance?
Oh, goodness.
Well, there's a quick answer. If you're an employee, you're entitled to minimum wage, you're entitled to a certain amount of sick leave, and I believe you're entitled to some form of health insurance. Proposition 22 specifies what you would get or what you can get if you're an app driver, if that's the right term, app driver. So that specifies those benefits. What you get if you're an employee is up to what the provisions in the labor code and the minimum wage law. I think that's accurate. I've got a chart somewhere which says what the.
That's what I've been looking for.
Oh, here it is. I've got it here.
Yay.
Under AB 5. Under AB 5, if you're an employee, that's AB 5 is the law that's currently in effect. You need at least minimum wage. You get overtime. You get expenses, and there's a health care option. You get workers' compensation, paid family leave, paid sick leave, unemployment insurance, and union rights could be possible if the legislature adopts it. Under Proposition 22, if you're an independent contractor, that you're an app driver, it's an independent contractor, you get at least 120% of the minimum wage, some mileage reimbursement, health care subsidy, accident insurance, which protects you if you hit somebody when you're on the job, new anti-discrimination and public safety, which is essentially a rest policy. And in order to unionize, there would have to be a 7/8 majority, supermajority of the legislature, and it preempts local jurisdictions from setting their own rules. So that would be in concrete. So that's the difference between the two.
Thank you. And one last question in this grouping. Someone would like to know who is proposing and supporting Proposition 23.
Ooh, good. You got it?
I do have that The, oh dear.
Well, 23 is the kidney dialysis one.
Yes.
Yes, yes.
Yeah, that's a fight between DaVita and Frenius. I think are the names of the two large companies that they operate the bulk of kidney dialysis clinics in the state of California. That's
And
who,
all of those clinics are for profit.
yes, they're all for-profit clinics, and they don't like this. They're opposed to it. Who is supporting it is a group of unions, and I think they're backed by this SEIU, but there's a healthcare workers union that's in back of it.
Thanks so much. I think it's time to move to the next grouping.
Okay. Ooh. Ooh. I need to clear my screen here. Am I on for this? Yes, I guess so. Group 4 has three measures in it. Two of them are quite straightforward and pretty linear, and one is a little bit tricky. Proposition 17 is a constitutional amendment, I believe was put on the ballot by the legislature. What it does is it modifies the provisions that disqualify convicted felons from voting. At present, the law disqualifies a felon from voting during the term of his sentence. And the way that has been interpreted is that sentence includes not only the time you spend in state prison serving your term, but the time that you're on parole after you've been released in prison. What Proposition 17 would do is say that you could, if you are paroled after the completion of your prison sentence, you may get your right to vote restored. That's pretty much as simple as that. The pro argument, and again, the fiscal effect of this is probably marginal. There may be some minimal increased costs. Every time you have more voters, you have more voter costs. People that are in favor of this generally favor the right to vote and believe that the right to vote would encourage the parolees to become productive members of society and aid in their rehabilitation. The people that oppose this believe that you don't get your right to fully re-enter society and get your vote to restore unless you complete all the terms of your sentence, including parole. And it's pretty much a up or down decision with respect to that. Proposition 18 is similar, except it involves 17-year-olds, hopefully, who haven't been convicted of felonies. Proposition 18 permits a 17-year-old to vote in a primary election and a special election if they will be 18 by the time of the next general election. It could be either a presidential election or governor election, but you get the principle. If you're old enough to be able to vote in the election that actually determines who's going to be in the office, then under Proposition 18, you should be able to vote in the primary election that determines the finalists who will run in that office. And again, here's the arguments are fairly straightforward. People that support the right to vote say, wait a minute, it's logical. If you're going to be able to vote in the general, you should be able to vote in the primary. 17-year-olds, they're plenty mature. The opponents say, no, not quite so fast. A 17-year-old can't pay taxes. And if you want to be able to vote in measures that have an effect on people's taxes and stuff like that, the least you can do is have to pay the taxes yourself and be 18. And there's also an argument about whether 17-year-olds are in fact mature enough to meaningfully cast a ballot. That's Proposition 18. Proposition 20 is a little bit trickier. Give you a little context in that. There are three significant pieces of legislation that affect this. One is AB 109, I think it's AB 109, which is referred to as the realignment law. And what that did is it gave responsibility for a large number of people that had been convicted of relatively minor crimes from the state. They were nonetheless felonies from the state to counties, and it shifted both the financial responsibility and the supervisory responsibility. There's some fiscal provisions that go with that. There were two initiatives. One is Proposition 47. The other is Proposition 57. Proposition 47 changed a bunch of crimes to be, quote, non-violent crimes, classified them as misdemeanors. Proposition 57 enabled another group of people that had actually been convicted of felonies, if they were deemed non-violent felonies, to authorize parole consideration for those people. Proposition 22 retrenches some of those, what some people would refer to as reforms. It tightens the law a little bit. It makes some crimes that are now misdemeanors, makes them what is known as a wobbler. It can be charged by the district attorney as either a felony or a misdemeanor. It has a big, long list of 50 crimes that are considered to be violent and thus ineligible for, if you're convicted of them, for this parole opportunity. Prop 20 also adds a couple new theft cases, serious theft cases, also wobblers for serial theft, for organized shoplifting and things of that nature. Again, this is a pretty much a criminal justice morals issue. Not all that much is gained by diving into the penal code and picking apart the various substations. It's generally a philosophical contest. The people that support Proposition 20 or support tougher sentences on crimes, they say that these reforms were too great, and a lot of criminals are being let out on the street. Violent criminals are being let out, and we should tighten it up a little bit. The people that are opposed to this say, no, this is wrong. We should be encouraging rehabilitation and community-based sentences, not keeping more people in state prison. That's what Prop 20 does. And with that, I'd ask Anthony, do we get any questions on this?
We just have one question for this section, Shane, and that is on Proposition 18. How does the law compare to what other states are doing?
I think a few states, somewhere in here, I have there's a number. If you give me a minute, it says, "18 other states allow 17-year-olds to vote." That's
Okay, that's pretty clear. We did get a follow-up question on Proposition 20. And the question is, who's proposing this and who's opposed to it?
Let's see, let me get that. We should have that pretty clearly. Well, like I've told you before, different contexts. I'm old, but I'm slow. But there's an answer as to who sponsors it. Ha! Did I say ha? the supporters of Proposition 20, I don't know that this is too much information. It's the Yes on 20, Protect Victims of Violent Crime, and they have a website, Keep Cal Safe, one word, initial caps.org. That's who's supporting it. I would suppose that they're organized crime victims. There are crime victims organizations, and I would imagine that the the organized law enforcement agencies would also support this. The opponents, to be even-handed about this, No on 20, Stop the Prison Spending Scam, in individual words, and their website is noprop20.vote. That's as much as I could tell you.
Thanks, Shane. I think those are the last questions in this section. I think everybody's eager to move on to the local measures.
Okay. This is actually a fairly light election for local measures as those things go. I'll give you a general hint. There are two pretty good sized school bonds. One is Cold Spring Elementary, which is a $7.8 million bond for new classrooms and modernized classrooms. The second is Measure L. Measure M is from the Goleta Union School District, and that's an $80 million bond issue for STEAM projects. They didn't have steam when I went to school. Hell, they barely had heat when I went. In any event, there's a whole list of projects. Here's the thing about school facilities bonds. One, they require a 55% vote. Two, in order to merit that 55% vote, they have to be limited to construction of school facilities. There are mandatory accountability measures that are built into that. And they always contain a project list. And the key to determining whether you think you want to support the school bond is whether you believe that project list is worthwhile to spend the money that the taxpayers are going to have to spend in order to construct the schools. Each of those websites has information put out by the individual district, which under the law has to be fair, balanced, and factual. You can take that for what it's worth. In any event, those are the two school bonds. There's one more measure that's worth talking about on the ballot. Pretty simple, Measure O 2020, the Goleta measure. A couple years ago, fairly recently, Goleta went to district elections. So they have 4 council member districts. They have a 5-person council counting the mayor. They have 4 council member districts who council members serve 4-year terms. Then they have a mayor who is elected at citywide, but the mayor currently gets a 2-year term. So question for Measure O is, shall the office of the mayor be changed from 2 years to 4 years? And I'm not exactly certain of what the precise arguments are, but normally you would think that the argument would be, well, if that council members are getting 4 years, the mayor should get 4 years. On the other hand, you can argue that, well, the mayor is the only person that's elected citywide, so it's better to have a more frequent election for the mayor. Again, all the information about that is on the City of Goleta's website, and it's at the bottom here. That, I think, does it for the measures, and I've now covered up the script. Here we go. Okay. Here's it. Yes. This is the slide that we talked about earlier, right? This is the one that had, this is the one that has all the information from the League of Women Voters of California. Pros and cons, highly recommended. It's got a separate page for each proposition. Goes into it in some detail. There's an easy voter guide, which is designed for new voters and is available in Spanish. There is a voter's edge, which allows you to personalize your ballot according to your own zip code. And then last, there is Vote with the League, which you can see the website down there at the League of Women Voters. Vote with the League, one word, all caps on vote, and which has the League's recommendations on some, not all of the propositions, but some of the propositions. But the one they have a recommendation on, they do give you detailed analysis and stances on their issues. Okay. Yes. So we are concluding here. Many thanks. You will note that Vote with the League, which I just mentioned, got that snappy graphic there, but it's a week from tonight, 7 o'clock webinar, Vote with the League, September 30th. You can register with the League of Women Voters of Santa Barbara website. I'm sure it'll be clearly displayed how you can do that. It's my.lwv.org/California-Santa-Barbara. Ooh, tricky with a hyphen. In any event, that's going to be next week and should be interesting. I hope it'll be interesting. Anyway, we're about, yes, vote. Remember to vote. Many thanks. I want to thank you for attending here. That's very good that we have such a large and interested audience with many questions. Thank you, contending. Many thanks to my colleague, Chris Bosch, for her assistance with this presentation, and particularly Reve and Anthony Moran for their heroic technical support, well beyond my technical expertise, which is turn on the Mac and hope for the best. In any event, thanks again for attending this webinar. Now, I got to pitch it for some money. The League of Women Voters, and particularly the Education Fund, we need money to put on things. If you like the forum, or even if you didn't like the forum, you're more than welcome to join the League. It's easy to join the League, or to make a tax-deductible contribution to the League's Education Fund, League of Women Voters of Santa Barbara Education Fund, to support voter education programs such as this. We will note that ballots will be mailed out to all registered voters starting Monday, October 5th. So soon you will be able to vote. I will note that there are many places you can get instructions on how to safely vote. Voting early is encouraged to make sure your vote gets counted, and that the post office and the elections division is not jammed up. I will also notice that I got my ballot pamphlet in the mail today, and this has got a lot of information on the state proposition. So if you are confused by us, got no excuse. You can rely on the state. Trust them. In any event, thank you very much. Good night.